Nice. All right. Hey, so this this should be relatively painless, although worldwide Volkswagen is like a kind of a complicated case a little bit, because like there's like layers to it that you have to figure out that aren't like necessarily evident from just reading the actual case itself. But it's also short, and from it comes like a couple pretty big rules that are gonna that you got to remember for like things like the final and for like future cases. So what we'll do is just to help you guys out, or to go through this. We'll go through that, like I'll go through that case brief template I sent you guys, and then just kind of work it together, talk about like, so we'll start with the procedural history, and then we'll get through like what are the pertinent facts of the case, and then we'll talk about what's the identified issue, like what's the defendant actually looking for, and then or not the defendant, but what's the plaintiff actually looking for, and then what does the court see as the issues in the case, and not just the Supreme Court, which is what the decision is, or who wrote the decision, but like the lower courts, what their reasoning was. And then we'll look at rules. We'll talk about what rules come out of this case, and then ultimately the holding, in this one is pretty easy, but we'll help you guys for it. So let's start with all right, so who is the plaintiff in this case? Like anybody can just chime in.
Worldwide Volkswagen Corp.
Yeah, okay, so who are they though?
They are a distributor who sold a car that eventually got involved in a crash somewhere far from where they sold it.
Yeah, right. So they didn't actually sell the car to the Robinson family, right? They're a distributor who took the car basically off the boat, stored it. They gave it to a dealership who then sold the car to the Robinsons in New York, right? And then they drove that car to Oklahoma, got in a crash, and somehow they ended up suing the guys who took the car off the boat, right? So that's the kind of the weird, so what they did was, and again, what you guys, like, you can kind of gather from this, and if you read, like, sometimes some people, like, if you have the digital version of the book, there's links and things to like other parts of this case, but they sued everybody. Is what they did. The Robinsons did a thing. We're suing Audi, we're suing Volkswagen, we're suing Worldwide, we're suing the what's the name of the place that actually sold them the car?
Seaway.
Yeah, Seaway. They sued them. So it was a big. They were just shotgunning and seeing what sticks. And then what happened is, in this case, like Worldwide Volkswagen's like, hold up, like we should not be involved in this at all. And then they counter-filed to because they were like, we're not gonna confirm, or what is it? What's the word I'm looking for? Basically, we're not going to submit to the jurisdiction of the Oklahoma courts where this thing started. All right, so that's the plaintiff in this case, who started out as a defendant, but then they are the plaintiff. Now, who is Woodson?
Wasn't Woodson a judge in Oklahoma? I forgot how specifically. I know, I forgot if it was Worldwide Volkswagen or Seaway that filed a writ against him, but I know he's a judge in Oklahoma.
Yeah, so he was the original district court judge where the Robinsons filed their suit against Worldwide Volkswagen, and he is the one that ruled, that said, yep, we do have jurisdiction, or jurisdiction over Worldwide Volkswagen. So Worldwide Volkswagen ended up suing him to get that reversed, and then that went to the Oklahoma Supreme Court, and then eventually up the chain. So it was district court for Creek County, Oklahoma. That's where Woodson is from. Okay, so then next thing is everybody's kind of tracking that. So like, even though it's like the Robinsons are the people that are actually wronged in this suit, they're not a party to this specific thing. They started the whole thing, but this was like an offshoot of that. And I forget, I think if I remember correctly, they actually did win a judgment against like Volkswagen for this, but it was against Volkswagen themselves. Okay, so what relief is being sought? Kind of easy.
Worldwide is seeking to have the lower court's ruling reversed, saying that Oklahoma does not have jurisdiction over them.
Yes, right. So they're saying personal jurisdiction is not, does not exist in this case. Like they can't reach out to New York and say, you guys fall under us. Okay, and then so now the trial court in this case is Woodson, the district court. So it's obvious. So as far as how they decided, it's, you know, they decide, yes, actually, they do. Now, what was the reasoning? This is where we start to get into that. What was the district court's reasoning in saying that Oklahoma, or that the district court in Oklahoma had personal jurisdiction over Worldwide Volkswagen?
Didn't they see that, I'm looking at, we hold that under the facts presented, the trial court was justified in concluding that the petition, blah, blah, that they should have foreseen that selling vehicles means that the vehicles are going to be mobile, they're going to go everywhere, and that you kind of should be open to liability everywhere because your vehicle is mobile and you should be able to be tried everywhere because that's what you're selling. And so the district court found that that was okay.
All right, so it's because they are in the business of distributing and selling what's known as like chattel, which is basically movable property, that it could end up in Oklahoma or it could end up anywhere. And so you are responsible for that. That's what the district court's decision was. And then how about like the Oklahoma Supreme Court? What did they say?
They affirmed the lower court's decision.
And so,
And
yeah, go ahead.
I was going to say they emphasize that cars get driven all over the place, making it foreseeable that a defect can cause problems in any state.
They also said that the petitioners derive substantial revenue assumed in the state.
Yep. Because they have, so for them, it's because they have the exclusive right to distribute automobiles in New York, New Jersey, and Connecticut, at least Volkswagens, that they know that those things are movable like chattel, that it's gonna end up somewhere else. And so they are responsible for wherever it ends up. Okay, so then Oklahoma District Court and the Oklahoma Supreme Court both say, you guys are on the hook for this. And then, so let's go over the facts. How do you guys want to go? Somebody just like go from like sale of the vehicle to where we end up. I mean, I guess, so in this case, we can kind of skip over, because in all honesty, like the facts here are the actual facts of the Robinsons buying a car in New York and then driving it to Oklahoma and getting in the crash and the gas tank exploding and the gas tank being some flaw in engineering that caused the explosion or the fire. That's not really, those are like dicta. They're not really not really something that you need to pay attention to in this. What you really have to pay attention to is what the court says, or what the Worldwide Volkswagen is saying about where they, where does Worldwide Volkswagen do business? Where do they advertise their business? What is the extent of their influence? Things like that. Those are the facts that are really pertinent here. It's like, what is Worldwide Volkswagen? Because they are limited in their distribution that they can't, that their position is like, hey, look, our responsibility is only this, like New York, New Jersey, it's what, New York, New Jersey, and Connecticut. They shouldn't, they're like, and their position is like, hey, like, we don't advertise, we don't tell people when they buy these things or when we distribute these vehicles, we're not sending them to people saying, hey, if you buy this car, you can travel to Oklahoma, or, you know, whatever it is. That's the pertinent part about it. The facts in this case is what Worldwide's Volkswagen is availing themselves to as far as like where they distribute their vehicles, where they advertise, and all that good stuff.
Yeah, because it's partly about what laws they are privy to, I guess, because of what protections they're taking on. Right? They're taking on a certain state's protections, therefore they have to answer for their missteps, I guess, in that state.
So and then the other thing is like, so this is also takes place in a time where the court had a couple decisions specifically in like the McGee, which the Supreme Court talks a lot about in here, where there's this movement where they're starting to loosen up on Pennoyer, right? So Pennoyer is where we start. And Pennoyer says like, hey, look, unless plaintiff and defendant are both in this state and this thing happens in this state and you can serve them papers in this state, like you don't have jurisdiction. But like almost immediately after Pennoyer, like things started to expand, right? And things like, and the Supreme Court talks about it in their decision. Yeah, there's like a TV or something somebody's got on. I just saw that like on the feedback. There you go. So what you have is like basically interstate commerce becomes more and more common, right? So the world is getting smaller, as they say. And so now interstate commerce is almost the norm. And so when that becomes the norm, then things like, you know, state borders become less and less important. Specifically, does anybody see where the court was talking about, well, I'm getting ahead of myself. Let's go back. All right. So the plaintiff's position is we shouldn't, you know, we only sell things in this specific area. So, and that's the only places where we would accept any kind of responsibility for anything that we sell. And then the defendant's position, or Woodson, or the court's position is the opposite, right? Is like, well, you should know that a car moves and that the car enables people to travel wherever they want. And you should know that people don't stay put and they move around. And so if you sell something like this, like I said, like chattel, you're responsible for wherever it goes. All right. And then, so like, now we'll get into the actual issues. So what are the issues? Let's go like one at a time. Let's somebody throw out one of the issues that the Supreme Court settled on or focused on.
Is one of the issues, I'm trying to figure out how to word this, but basically what I thought one of the issues was, can Oklahoma like exercise personal jurisdiction over I don't want to say defendant, but over, I guess, Worldwide Volkswagen. And I think they mentioned something about like, does that violate the due process?
Yes. But like within that, like, so that's the big issue, right? So like, is it within the due process clause that Oklahoma can reach out? Because that was, remember the Oklahoma Supreme Court used that long arm statute that they quoted, which is actually, it's gone now. The law that they were quoting or using is actually like invalid at this point. But so what Supreme Court is saying, okay, so that's fine, but like there's a lower level to that. So due process clause and that is the high level issue. But within that, there's reasonableness. And that is the defendant, is it reasonable for the defendant to expect or let me see, I'm gonna look at the actual, so relationship between the defendant and the forum must be such that it is reasonable to require a corporation to defend the particular suit which is brought, right? That's like, so within the due process, you have, or within the state jurisdiction by the due process clause, you have this reasonableness thing, like, can we expect them to actually foresee, right? And that's another kind of, I'm getting into like the second issue. So what do they say about that? About like the reasonableness of expecting Worldwide Volkswagen to defend themselves in Oklahoma?
They're talking about minimum contacts. That's one of the biggest ones.
And they also talk about federalism. Does the reasonableness of a certain jurisdiction must be assessed in the context of our federal system of government?
Yeah, and that goes into like the framers intended the states to have some sort of sovereignty. And so when you have a corporation like Worldwide Volkswagen that is incorporated and does business in New York, so they are like submitting themselves to the jurisdiction of New York. We want to work and live and do our business in New York. Is it fair or reasonable for Oklahoma to be able to reach out and grab that corporation and say, we're gonna, you're gonna now fall under our jurisdiction, right? That's, and that's where the federalism thing becomes an issue, is they start to say, well, we understand that interstate commerce is a thing, and it's very like it's getting less and less important, like it's the sovereign or the or it's making sovereignty between the states less and less important, but there's still a line we have to draw. We have to draw a line, and where does that line exist?
Can I ask a question? Would
Yeah,
it
go ahead.
not, and this might, all of my questions are going to be very amateur because it's our first year, but would it not have made it a lot simpler had the Robinsons simply, gone to court in New York, for example, or wherever is closer? Like, I get that the accident was in Oklahoma, but could not their attorneys or whomever have advised them to just, hold your case in a state that is more related to Volkswagen? So to me, this particular case is like unnecessary. Like, just have it somewhere closer to them so Volkswagen doesn't come back and say this exact thing. Hey, Oklahoma, you don't have jurisdiction. Why are we having it here just because the accident happened here, as opposed to having it where Volkswagen has unquestionable, or where, a state has unquestionable jurisdiction over Volkswagen?
But the meat of the case was like the actual personal injury. I would think this is like a spin-off of it. And for the personal injury side, I would think that they would want all of the medical professionals that were there and all of the emergency response or whoever that dealt with the actual crash and actual injuries. Like, it makes sense for the meat of the case for it to be in Oklahoma because that has to do with the accident. So they want to be able to pull all these witnesses. But yeah, I mean, I think you're right. It's just that this is like the remainder of a bigger case. And so it's like, I don't think that they can, I don't think, if anyone knows, like, I don't think that they can spin this off into a different jurisdiction. I think they have to stick with the same jurisdiction for the entire case, I believe.
I think if they sued them in New York, we definitely wouldn't be talking about it right now. That's for sure.
Yeah.
But if they sue them in New York, they might not have won the personal injury side.
There has to be, so there's at the, and this case gets into those key kind of things that come into consideration when it comes to like the jurisdiction, like when can a state exercise jurisdiction? So this is a weird one because like Oklahoma, like Tiara was saying, like Oklahoma is only like tangentially related to this because the Robinsons are from New York and they're going to Arizona. They just happen to be in Oklahoma, right? And so one of the key elements of like jurisdiction when the court lays out their like elements of jurisdiction is what's the state's interest in making sure that justice is like done in this case. And what you have here is like Oklahoma, like they have none. Like those people aren't from Oklahoma. They didn't buy the car in Oklahoma. They're not gonna live in Oklahoma. They're just passing through. And so that's the thing. But for the Robinsons, now they're just like, and apparently because the wife got burned. And again, this is stuff that this is like dicta that's like outside of the case itself. But apparently because of this accident, because of the injuries to Mrs. Robinson, like they got stuck in Oklahoma, like they couldn't go anywhere else. And so at the time it was like, it was most convenient for them. And that's also another consideration. It's like the person who's wronged, like how much can we expect them to have to go back to New York and file suit in order to fall into this? But one way that you can get over that, and this is something that's going to come up later on, I think, for you guys, is elevate it to federal court. Like, why are you suing them in district court? You should have taken it to federal court, and then federal jurisdiction would have like blanketed all of this stuff and you wouldn't have had to worry about it. They might have changed the venue on you, but once you take it to federal court, like in the District of Oklahoma, then the federal court can say, okay, yes, federal court has jurisdiction. They may move the venue to like New York, but you'll at least get started instead of losing everything. Like in this case, as far as Worldwide Volkswagen is concerned, again, Worldwide Volkswagen was just one of several people that got sued by the Robinsons in this case. Again, I'd have to go back and look, but I'm pretty sure they ended up winning something against like Volkswagen themselves. But it was just because they wanted to file against Volkswagen and all these other, they brought all these other people in, and then basically that lawsuit got carved up into pieces, and then each individual defendant started fighting it their own way. And Worldwide Volkswagen happened to be the one that we end up talking about because they got sucked into it without like, hey, like, again, it's unreasonable for you to expect us who only want to do business in New York, New Jersey, and Connecticut to be responsible for something that happens in Oklahoma.
And again, they were just the point of sale, right? That's all they were involved in.
They weren't even the point of sale. Again, they're a distribution.
I don't remember what they're the distribution center that sold it to the point of sale or gave it to the point of sale.
They sold it to the dealership. The dealership sold it to the Robinsons.
Okay.
And so like they were just a link in the chain. And
yeah.
The Robinsons or whoever their attorney was, which their attorney was probably pretty smart, and be like, we're going to sue all of them and see what sticks.
Yeah.
You know, because you sue the dealership and they're, small potatoes, but you have to work your way up the chain to try to get after the big fish, which is, Volkswagen, or in this case.
Well, if they got something against Volkswagen, they're probably fine.
I mean, as fine as you can be. Like I said, the wife was pretty hurt. But let's go. So let's talk about what Tiara was talking about with the, I highlighted it on my thing because I really wanted to talk about that.
Wait, Paul, I have a question.
Mm-hmm.
So not to go back on like what the issue was, but I think I'm a little confused on that because I feel like there's like 3 different issues within this case.
There are.
Is it okay to have those 3 issues, or is there like one main issue amongst the 3 that?
So I'll give you so that really there's two issues that come out of here that you really gonna have to hold on to as far as like when you guys are thinking about doing your outlining and your final.
Mm-hmm.
So one of them is the purposeful availment is number 1, right? Did Worldwide Volkswagen knowingly and like foreseeably and purposely avail themselves to the jurisdiction of Oklahoma by selling a car in New York? Or not even selling a car, again, by distributing cars in New York, did they purposely avail themselves to Oklahoma's jurisdiction? And the Supreme Court's answer to that is no. All right, so they say traditional sovereignty rules restrict personal jurisdiction over corporations to places where they have substantial activities, meaning they have a headquarters or they have a factory that builds the things. And then they, factors to, so then they get into the factors, and this is what what we were just talking about. So there's 4 factors that you need. These are the big things that have to come out of this. So 1, did the party actually solicit business in the state? In this case, no, right? I keep losing my spot. Is there a physical presence in the state of the corporation? No, in this case. Did they deliver the products to that state? No, they didn't do that either. And then the 4th thing is there some foreseeability that it will end up in the state? Now, so what the what the court in Oklahoma said was foreseeability wins over everything. Like, you should have known that you sell cars and cars move. And so you should have known that it could have ended up in Oklahoma. And by being able to foresee that, you have availed yourself to Oklahoma's jurisdiction. But the Supreme Court said, no, that's a factor, but it doesn't stand alone. There's these other things, like, are they advertising? Do they actually distribute things to that state ever? And then do they deliver their products to that state? So what I say, yeah, do they solicit business? Do they have a physical presence? Do they deliver the products to that state? And then, so that's issue number one, is that purposeful availment. And those 4 elements are things you have to, like, when you're analyzing these problems, like, did the corporation do these 4 things? And then the other part is the interest of the parties involved, and you have to take both, right? So when I think it was McGee, you had the substantial connection. That's like the interest of the state and the plaintiff. Like, that was fairness to the individual versus the corporation, the location of the witnesses, right? So if it makes sense to have it here in Oklahoma, because everybody involved in the case was in Oklahoma when it happened, right? The person that crashed into them, all the witnesses, all that stuff. Like, does it make sense to keep it in Oklahoma versus moving it to New York? And then the value of to the state, right? And this is where we're talking about, like, so if the state is like, these are Oklahoma citizens, this is important to us to get justice for our people, so we should be able to have jurisdiction. But in this case, none of that really happened, right? There's no questions about, like, the Robinsons themselves are not Oklahoma citizens, right? So the Oklahoma's interest in getting them justice is pretty limited. Anyway, so that's part one of the interests of the parties. Then the other part is the court weighs the interests of the parties when determining jurisdiction, including the interest of now the defendant, in this case, Worldwide Volkswagen, right? So what's the cost to defend themselves in a state where they don't do business, where they don't have anything? What is the and then there's the interstate judicial system's goal of efficient resolution is another issue, and then the collective interest in social policies. So you don't want to open the door, basically, what they're saying is, like, the court is saying, like, if we let Oklahoma exercise jurisdiction over this corporation in New York that has no other connection to Oklahoma other than somebody that one time bought something that used to be in their possession. Again, they didn't even sell it to those people. How could, we're just opening the doors, and everybody's going to be able to sue anybody anywhere and, like, just claim jurisdiction, right? That's the big issue where they're like, we got to put a little bit of boundary. You got to keep some of these state boundaries. And that's where, like, some of the federalism stuff comes in, where they're trying to maintain at least the illusion that there's these lines that, we're trying to follow, if that makes sense. Does that help?
Makes sense.
And some of this will make a lot more sense once you build on it, right? So again, this is foundational stuff. It's like Panoyer, it's weird, because it by itself, it doesn't make a lot of sense. But then when they start stacking cases on cases on cases on top of it, like, you get the whole context of it, right? And so this is a part where it's like the beginning of that rule, and then, like, the subsequent cases that you guys will read after this. Like, there's the Burger King case that you guys will read after this one, where basically it's like I won't get into it. That's, again, it talks about the same thing, because there's a guy's like, hey, I do business in, like, I think he was, like, in Ohio or something. He ran a Burger King franchise in Ohio, but the Burger King headquarters is in Florida. And he's like, you guys can't sue me in Florida. I do business in Ohio. And they're like, well, actually, when you signed up with Burger King, you knew they were located in Florida. So you knew that you would get sucked into Florida jurisdiction if something went wrong.
Oh yeah, however you say his last name, I can't remember. It's crazy. Some crazy.
Yeah. It's like one of the cases that coming. So like, that's where you start to get some of the context of these things and you start to weigh those factors. But the first 4 factors that we were just talking about, those are the big ones. And I think if you look at, so you guys have a different book than I had. So I can't, I wouldn't be able to tell you what page it's on, but there's like a big paragraph under part 2 of the decision. The paragraph starts with the protection against inconvenient litigation is typically described. And at the bottom of that paragraph is where they lay out these relevant factors. So they say, the court says, relationship between the defendant and foreman must be such as reasonable. And then they say implicit in this emphasis on reasonableness is the understanding that the burden of the defendant, while always a primary concern, will in an appropriate case be considered in light of other relevant factors. And then here's where they say, forum state's interest in adjudicating the dispute, the plaintiff's interest in obtaining convenient and effective release or relief, and then the interstate judicial system's interest in obtaining the most efficient resolution of controversies and shared interests of several states in furthering fundamental substantive social policies. Do you guys see that paragraph? That's a big, like, that's like, bang, there's your rule right there. And then the other one.
Wait, where do you guys see that paragraph?
For me, it's page 701.
Okay.
I have the digital book though, so I don't know.
It's the 3rd paragraph under section 2,
Yeah.
the very last,
okay.
long sentence.
I see it now. Thank you.
And then that other rule I was talking about is in part 3, where that's those 4 factors that include foreseeability as the 4th one, but not the sole one. So if you look down in that part 3, let's see if I can find exactly what I'm talking about. Here it is. So it says, there's a paragraph. It says, there's like one sentence where they say, if foreseeable, well, I don't know if it's one sentence for you guys, it's one sentence for me, but you know how they cut up these cases for the textbooks. So your textbook might be cut up a little bit different than mine. But it says, like, if foreseeability were the criteria, every seller of chattels would in effect appoint the chattel his agent for service of process, and his amenability to suit would travel with the chattel. That's basically saying, like, if we just say, if you sell a car and that car ends up in Egypt, then you're subject to Egypt's jurisdiction, right? That's, but then the next paragraph is where they lay out those other factors of, okay, so foreseeability is a thing, but it doesn't stand alone. This is rather its defendant's conduct in connection with the forum state that are such that they should reasonably anticipate being hailed to court there, right? So there's the conduct, and the conduct, then they break down into, do they have a headquarters there? Do they have a factory there? What's their physical presence, basically? And then the other factor is, did they solicit business there? And then do they actually deliver products to the state?
So it seems like all of those things are under the umbrella of personal availment or purposeful availment, right?
Yeah, right. Like those, like when you go through it, it's like, it's so, because again, like what Oklahoma was saying is you should have foreseen it. Cars have wheels,
right?
Cars can end up in Oklahoma. We have roads. But the Supreme Court said, no, that's a thing, but there's these other things. Like, did they actually do anything in Oklahoma? Or did the car just end up there? And those are the 2 big rules. So did you guys see that paragraph I was talking about? In it's like I said, it's like down in part 3. Just trying to make sure that you guys have the same.
It is the 4th paragraph. It's between 2 longer paragraphs.
Okay. Yeah. See, for me, it was a little bit different because it was like they just cut out like a sentence in the paragraph before it, and then. Okay, cool. Well, so like, what else you got? What other questions do you guys have about this? Like, as far as like being able to pull these things out of the case, because that's what I really want you guys to see is like, you know, how do you know the the procedural history? How do you know what the relevant facts are? Things like that. Like those, that's what I really wanted to help you guys out with this one.
I guess my question would be in this template that you gave us,
Mhm.
where would you take notes on like the tests in the ruling? So like the 4 factors that were in part 2 and then the factors that are in part 3, where would you put that in our little grid?
Oh, so for that, I would put it in the, so I would go issue, rule, right? That's the way, like the IRAC. All right, so the issue being, what are, like, at what point does a corporation avail itself to the jurisdiction of state, right? That's the issue. Then the rule is, well, you have to consider these 4 factors. And the rule is, did they solicit business there? Do they have a physical presence there? Do they deliver their goods there? Or is there foreseeability that, you know, their product would have some effect there?
Gotcha.
Yeah, and if you guys don't have it, like, just shoot me an email if you don't have that Excel sheet. I sent out like a real quick case brief table that I made in Excel. And, you know, if you guys don't have it, there it is. If you guys don't have it, like, just let me know. And then the same thing with my outline, but we'll go through the outline thing like later on after you guys get through. I think we'll go through, I'll let you guys get through like original jurisdiction and personal jurisdiction. Or no, I'm sorry, specific. I'll let you guys get through specific jurisdiction and general jurisdiction. And then once you guys get through that, then we'll reconvene and we'll do another kind of class like this, either on Zoom or we can do it in person in the library or something. And I'll go through and I'll help you guys like build out outlines.
There's a light at the end of the jurisdiction tunnel. Is that what you're telling me?
Jurisdiction is a huge part of civil procedure. But that's just personal jurisdiction, right? Is the specific and general is personal jurisdiction. Then you get into subject matter jurisdiction, which is even longer and more confusing, sadly.
I get confused. Oh, sorry. I get confused with these, I guess, this would be considered an appeal case because Worldwide is appealing against the ruling of the state court. But I get confused when they still refer to the litigants as plaintiff or defendant in the appeal, because, and even Professor Colson said it. He mentioned like, yeah, it's confusing because even today we still refer to them as what they were. When they refer to them as either respondent and petitioner, I'm a little more on top of it because I'm like, we're talking about this case. But when they refer to them as petition or as a plaintiff and defendant, I get confused, specifically in Penoyer. I got so confused because, again, like he said in class, where is Penoyer? Like I'm seeing Penoyer in my mind as the plaintiff in this case that we're reading, but we keep referring to the Mitchell and I forgot their name and Neff, and I'm just getting confused with keeping everybody in place, and it doesn't look like it's gonna work out in my favor of not confusing. So I need to figure out how to understand it when they're confusing me.
Wait until you get to, there's some places where you have like a case where you'll read all 3 decisions and it'll be like White v. Young, and then Young v. White, and then White v. somebody else because Young got knocked out and now somebody else is in there. And it's all the same case. And it's all talking about the same stuff, but like the characters change and who's in what position changes. So that's just like and the good news is you don't really have to know that, like in the end. I mean, you have to know it to understand the case as you're reading it, but then when it comes time for the exam, like I said, for Worldwide Volkswagen, that rule where it's like, all right, purposeful availment of corporation, did they sell their product there? Did they deliver their product there? Do they have a factory there? Is it reasonable to expect that their thing, or is it foreseeable that their thing would end up in that state? That's all you have to know from Worldwide Volkswagen. You don't have to know about Mrs. Robinson getting burned and, you know, who sued who and all that stuff. All you need to know is like, per Worldwide Volkswagen, here's the elements of purposeful availment, and then you apply the facts to that, right? So that's your analysis, your issue, rule, analysis, and then you come to a conclusion, which you guys will get more stuff on the exams. Your conclusion is always going to be like, maybe, in your exam, there's never a clear answer. You're going to say, well, it looks like maybe they availed themselves, but the court could also say they didn't avail themselves because of these things. Right? What else you guys got?
Okay, last thing I'm gonna ask and
No.
allow other people to ask questions. So the conclusion of this case, on page 704, because we find the petitioners have no contact, the petitioners being worldwide, have no contacts, ties, or relations with the state of Oklahoma, the judgment of Supreme Court of Oklahoma is reversed. Not remanded, so it doesn't go back to the state court, but it's reversed. So they have found in favor of worldwide, correct? Simply by saying it's reversed, they're ruling in favor of worldwide simply by saying it's reversed, correct?
Yeah, I mean, because this case, the specific question that the Supreme Court certified was, does Oklahoma have jurisdiction over worldwide Volkswagen in this case? And the ultimate decision was no. And so you can't remand that for further proceedings because you're done.
I've got a question.
Go ahead.
So it seems like the fallout from this case was particularly confusing because some of the dicta that came up as a result of this case was looked at. And then there was the holding, which was saying other things. And then they both in future cases tried to come back and say, well, this was said in Volkswagen and and some people were saying this is the holding. So, I mean, perhaps it's not very pertinent in terms of this semester and what we need to know, but does anything come out of that that's notable that's going to affect our understanding of future cases?
Let me think. I'm trying to think of like what the future. I'm gonna look at this thing. I see what I can see that like maybe.
And that's probably you didn't prepare to answer that question. So sorry about that. But.
No. So what happens is, like I said, you start with Pennoyer and you have this real easy rule where it's like, if you aren't in this state and they don't serve you your process in this state, then there's no jurisdiction, right? And then so like you
world
start
got
off that,
complicated.
Easy, and then all of a sudden like things start to like get more and more complicated because like, well, like with International Shoe, you had a salesman in that state and you should have known, things like that. So yeah, it's gonna, like, this isn't the end. All right, so then what they'll do is, so the court says, here's your 4 elements of purposeful availment, and then you're going to have all these subsequent cases that are going to take each one of those elements and start tearing that into pieces too, because now it's going to be like, oh well, what does delivering or what is physical presence in the state, what does that actually mean? Like, especially in the digital age, physical presence, like if you have if you advertise, I don't remember if I think that's in tort law, but there's like cases where it's like, well, you bought a Google advertisement and that Google advertisement ended up on somebody's computer in New Mexico. So now that, you availed yourself by advertising in New Mexico. So, you got to watch it. So it's a little, things are never easy.
So the prevailing holding going forward from this then is chiefly concerned with purposeful availment.
Yeah.
That's
purposeful availment, and then it also expands on. So you guys should have had like so you start with like minimum contacts with International Shoe, and then this stacks on top of that, where it's like, okay, well, minimum contacts also means you have to purposely have made those contacts, and here's what that means, right? And then the other thing would be the interest of the parties, right? So when you had, I think it was, what was the one I was looking at? Oh, well, the other purposeful availment was the Hansen v. Decla. I don't know. Did you guys read that one?
No,
Okay.
I don't think so. I could be wrong, but
Maybe not yet.
It's like in the reading, but not like highlighted out. I think it's like right at the beginning. But then they reference it a ton, so I'm like, why didn't they just separate this out?
So that was where they started to, so McGee, well, there was like Henson v. Dekla, and McGee started this like, well, what's fair to everybody? And like, what are the interests of the state and what are the interests of the defendant, the corporation itself? And like, you know, and so they started that. And then Worldwide Volkswagen is like, all right, well, here's what's fair. And we're gonna, you know, put it into these categories. But then you start to get into like, so now that like delivering, what was it? Delivering products to state, that becomes stream of commerce. And then there's like 4 or 5 cases that talk about stream of commerce and how you avail yourself based on that.
Question for you, Paul. Did your class have the practice perfect quizzes and stuff like we have?
For CIPRA?
Yeah.
I don't remember specifically now.
You would remember.
Yeah.
So we had not practice perfect. We had another one that was like acing Civ Pro or something like that. It was like a supplement, a little booklet, and it had like little quizzes and stuff that we had to take, but didn't sound like something that we did practice perfect.
Yeah, we have to do the practice. We have to watch the videos and then take the quizzes. And as Professor Colson also recognized, like you watch the video and like he said, I could be misquoting him, but he was like, it's like the Sesame Street, you know, the videos are very simple and they break it down really nicely. But then the questions, the supplemental questions and quizzes are all extra detailed and in-depth and harder. And I was like, this is crazy, but I'm glad he recognized it. But I'm also learning that in the syllabus, he outlines the cases that we should read first. And then it says, you know, watch the practice perfect video. And I was like, well, I can do the video real quick. So let me watch the video first and then answer. And then I'm like, oh, shoot, I don't really know what these questions are about because they're from the cases that I'm assuming we should have read first. I'm just expressing like how the learning curve of this environment and trying to figure out the right way to learn things. And
that's one of the best things is like about the syllabi, I guess, from all the professors is they really do like they break those things down in a way that like you should be doing it in this order. Like that's why like sometimes you'll skip big chunks of the textbook and you'll jump to the back and then back to the front. And but if you follow that syllabi, specifically when you're talking about making your outline, if you make your outline follow the way their syllabus goes, then when you get to the exam, the way you're going to be doing your issue spotting and the way you're going to be writing your answers for the exam, it's going to go right down the list because this stuff, like for here, it's like the very first thing you're going to do when you start doing your issue spotting and you start, writing your answers to these fact patterns is you're going to start with personal jurisdiction and then you're going to move to subject matter jurisdiction and then you're going to move to these other venues and things like that. So there's like an order, like almost like PEMDAS or please excuse my dear Aunt Sally, like in math. There's a way that you're supposed to go here to here to here to here when you answer these things. Cool. You guys got anything?
Paul, I think one of my questions, and I think we started to get into that in this case, I guess in terms of case briefing in the issue section itself, I guess how specific or broad should that be? Like, should it be something that's really specific to the case, broad in terms of like how it relates to a rule, or is there some like line in between that we're looking for? I think I'm just having trouble figuring out what's dicta that isn't the issue itself versus what issue I should be specifically focusing on.
So issue spotting is like the hardest part. And like sometimes it's super obvious in the case and they will say, the Supreme Court says, we are here to answer this question right here. And then, so bang, they gave you the issue, like and that's the best when they do that. But then sometimes they don't do that. And they'll start with something like really broad, like in this case, like the issue is whether or not worldwide Volkswagen falls under Oklahoma's jurisdiction, which that's entirely too broad, because that could mean anything. Do they have personal jurisdiction? Do they have like specific jurisdiction, whatever it is, right? So that's not helpful. So sometimes you just have to like dig through and find, based on the way they analyze it, they're like, okay, so the issue is this that they're looking at. So for example, in this case, what you end up figuring out is Oklahoma said the issue is worldwide Volkswagen should have foresaw that this vehicle would end up here, and therefore they would end up in our jurisdiction. And so the Supreme Court jumped on that and said, nope, like, yeah, or they said, yeah, foreseeability is a thing. However, it's not the only thing. And especially in something like this, where, there's any, like so wide a range of likelihood that a vehicle could end up in Oklahoma or not end up in Oklahoma, that there's other things you have to consider. And then they give you those other things. And so that's where they jumped on, like they identified the issue as that's too narrow a thing to just say somebody could foresee that their product would end up in a state. Instead, you have to add these other things to it. So sometimes you just have to translate it, and it comes like talking about it like this and talking about it in class, that you figure those things out. But that's where like for the purposes of taking an exam, that's what you always should walk away from with any of these cases is what's the issue that this case was focused on, and what's the rule that the court made, via that issue. And you walk away from every case that you read with those two things, you're going to be successful in the exam, as long as you can then identify the issues in the fact pattern that the professor gives you in the exam. But Professor McLean gives a super good issue spotting class that like towards the end of the semester, like October, November, we'll reach out to him and we'll set up a time for you guys to all get in there. It's usually like 30 minutes before class. He'll, if you guys have class at 6:30, he'll be like, hey, show up at 6, and then he'll give it to you. Unless you guys want to do like a longer one and people are available. But his issue spotting class is really good. And like, that's where, when we took that our first semester, is where it clicked for me. It was like, oh, so that's what I should have been doing this whole time, is figuring out what the issue is and what the rule applied to the issue, instead of focusing on all this, these facts about Miss Robinson catching on fire and stuff like that. Like, none of that matters.
Can we not do that like next week?
I have one question. So Colson basically dismissed a lot of the dissents. Like he says, he basically doesn't read those. Is that ever a thing where we have to pay attention, or will the professor point that out? Because I felt like he went through the cases really fast. Like for all the time that we spent on the cases outside of class, I feel like we barely touched on them. And I was like, wait a minute, dude, I'm ready to answer some questions. And he's like, no, we're just gonna go right by these. Hello, Kat. So do we ever have to focus on the dissents or anything like that? Or is that just
so sometimes yes. But usually what it is like, I'm trying to think, like, so in con law, you'll see this, where you'll start out with, like, as the rules start to change, you'll see the dissent, like people will start like kind of shifting towards the dissent, right? So it'll be like one Supreme Court justice is like ahead of the ball game, where, like, I can tell you, like, there's like Fourth Amendment, like one of the early Fourth Amendment cases in like the 1920s, the dissent is like, because it was, so it was whether or not wiretapping somebody's phone, if you never enter their property, is a search, right? So basically the cops, like, they plugged into this guy's phone line, but they did it outside of his house. And so they never went in his house. And the Supreme Court at the time was like, no, that's not a search. They didn't go into his property. But this one justice was like, hey, like, Fourth Amendment isn't just about invading somebody's property. It's about their ideas. It's about like listening in on their conversation. It's all these other things. And he, even in that thing, he's like, I can imagine a time in the future where like the government can get all of your papers without even ever having to print them and things like that, right? He was basically foreseeing like computers. And and so like what you see is
Now it's the entire legal backbone of how the NSA operates.
yeah, it's like, it's, like what you start to see is like, you'll see like that one Supreme Court justice will say something in a dissent like that, and then it starts to gain steam in later ones. So sometimes like it becomes the context behind a lot of the new rules in the dissent. And so when that happens, a professor may say, hey, you need to pay attention to the dissent because there's stuff in there that's going to come up later that's going to be important. In some cases, like, I mean, I know like Thurgood Marshall is like like he's the king of that. Like he wrote so many dissents that are like, now that's the thing. Like basically you can go back and look at every dissent that Thurgood Marshall ever wrote about like police and things like that. And it's like, that's now like what we take as like the truth. And at the time it was just him. So
Wasn't
yeah.
RBG a big thing too? Wasn't she a big dissent writer for a long time that then gained steam and blah blah blah?
Yeah. I mean, then you have those, like there are those like kind of visionary, and usually it's the ones that are they start young, right? They start in the Supreme Court very young, and at the time they're the radical, and then but as time moves on, it's like, oh well, actually they were right this whole time. So, but again, like the professor should be just like signaling to you to read the dissent. If not, sometimes, yeah, it's just a waste.
I have a question about the foreseeability thing. It sounded, when I did the reading, it seemed like they were saying that you have to foresee that your conduct in a state will lead to a lawsuit, but otherwise it's like, don't think about foreseeability because it's not about your expectations, it's about your actions. I don't know. I was kind of confused, like how to integrate that as like a factor, I guess.
So what you'll see is that's coming up. So like the foreseeability thing, again, it's like right in this case, they're like, it's just not enough by itself. And what you said is exactly right. It's not so much that you can foresee that your car would end up in Oklahoma, like, because of course a car can end up in Oklahoma. It could end up anywhere, right? But what ends up becoming part of the formula for foreseeability is like, did you do things to make it so that car ended up in Oklahoma? Or were there indications that showed you like, not only is there not just a chance it ends up in Oklahoma, like it's on its way, like, and that's where stream of commerce is going to clear that up, because it's not going to clear it up. It's going to muddy the waters is what it's really going to do. But they start to get like finer and finer and finer, because you start to have those things where it's like, you sold this thing that you knew was going to be like, I think, I may be getting into torts again.
But you're thinking of it like you foresee where it's going to, and like with Volkswagen, right? If you're like, oh, well, I can foresee that the gas tank is going to blow up, like wherever the car is going to be, like it's going to blow up. So like, that's not what you're foreseeing. You're foreseeing like where it might.
You're foreseeing that you would become, or you would avail yourself to the jurisdiction of wherever.
You're foreseeing like the position you could find yourself in, basically, like the jurisdiction you could find yourself in, because the blowing up was a defect itself, right?
Yeah, like it's not. That's the thing that I guess I'm finding confusing. It's like you're supposed to foresee your action resulting in a problem, but not just that. You're supposed to foresee your action resulting in a problem in a specific jurisdiction. So it's like you can foresee that your gas tank is going to blow up, but you didn't foresee that it would happen in Oklahoma. So Oklahoma still doesn't have.
So it's only the defendant's action. The plaintiff's action has nothing to do with it. So in the case of Worldwide, they sell in only 3 states. If they may end up getting off later in the case, but if the gas tank had blown up in one of those three states because they do business there, because they make sales there, because they benefit from the protections of the laws of those states, they've made themselves, they can foresee that if an action were to be taken against them, they could be under those states' jurisdiction. But because they don't do any of those things in Oklahoma, which stems from the plaintiff's action, they are not subject to Oklahoma's jurisdiction. How'd I do, Paul?
Yeah, no, that's right on. Like I think Sasha, if you like coming up, you guys should be reading a case called Calder v. Jones, and that case talks about the location of the effects of your action, not the person, not the other person. Your actions is what determines whether or not there's jurisdiction. So in this case, just like Max said, their actions would have made them responsible for things that happen in New York. The Robinsons' actions of driving that car to Arizona and then getting in a car accident in Oklahoma were not foreseeable by Worldwide Volkswagen, so they can't be held responsible for that.
They categorize it as the unilateral activity of someone who claims a relationship with a non-resident defendant.
So that's the other thing that I found confusing when in the reading. I think Jill maybe had brought it up in class, the Taiwanese company and the Japanese company ending up in court in California, and obviously that didn't make sense. But like the international, like if somebody doesn't have a home state, then there's just nobody who's gonna be able to have jurisdiction over them. If like oh, with the case about the English like shearing machine, and then it was like, well, he couldn't, the accident happened in New Jersey, everything occurred in New Jersey, but the company was English, and so it's like there was no place that really he could
Federal court would have to hear that.
Yeah, like was that, I mean, so there's no place you can get relief, or did I misunderstand that?
It would just be, yeah, so it would become a federal jurisdiction thing, because what happens is, so again, their action was, we're going to make this sheep shearing machine and we're going to give it to this distributor somewhere in the States. And then that distributor, so again, so their purposeful availment or their action was just distributing to this specific place. Then beyond that, like if that distributor takes it and sends it out to California or Florida or wherever, like they can't foresee where those things will go, and they didn't do any action to make it go there, right? So yeah, they can't be, as far as the state jurisdiction goes. Now, like you want to do business in the United States, and then you're going to import all this stuff, then the federal courts are going to start to be like, okay, well, you're harming US citizens at large with this stuff, and that's where the federal court will come in and say, hey,
that's the one where in the end it was like stream of commerce by itself is not gonna convict these people based on jurisdiction, right?
And that was so even that, like that one ends up like let me see, which one was that? That was the
It was McIntyre.
Is that
something. Oh, sorry.
Yeah, okay, that McIntyre, that's the one.
Yeah, it was McIntyre v. Castro or something like that. I forget the.
So what it said was like, so issue is stream of commerce, right? And the rule there is the actions of a corporation in the stream of commerce must be weighed against the expectations or probability of products ending up in a state. Sending products to independent nationwide distributor is not enough to avail them to the jurisdiction of any specific state.
So your only choice is to take it to federal court.
Yeah, you would have to do federal in that case. Because yes, because they're international, right? They were based in England at that point.
But if you want to just the distributor, you could feasibly sue the distributor wherever they were located and wherever they actively marketed and sold, correct?
Yep, because and then that takes you back to the worldwide Volkswagen thing. So did the distributor advertise in your state as like, hey, we sell these cheap sharing things? And then did they deliver it to your state? Yep, they did. And then the other thing would be, do they have a factory or a presence in that state? That one, you may not make it, but you're going to get 3 out of 4, right? Because the distributor is definitely going to foresee that, this thing, if something goes wrong, it's going to happen in that state because they delivered it to the state. And then if they reached out and advertised, it was like there's another case where it's like a national publication, right? So they're like, if you print newspapers and you publish them all over the country, then that your stuff's going to end up there. And if like you say something, libelous or whatever, you're going to be responsible in whatever state the person happens to be when they read it.
Well, wasn't part of that too that the defendant also reached into the state in their reporting? Like it wasn't just solely, the decision wasn't solely based on, this one was fun for me because I'm a journalist, so I was like that one. But it wasn't solely based on the publication, though that might have been enough, but also the reporter reached into the state to do harm in their reporting. And
Research.
That's also a consideration.
I mean, during their research.
Yeah.
There's a couple, I think, isn't there a couple of, I may be confused, I don't remember the specific, I remember there's the Hustler one.
It sounds like he's talking about the Calder one. For Calder v. Jones.
Oh yeah, Calder.
The National Enquirer one.
Yes. So that is like, if so that there's where like, so even if like maybe your distribution doesn't go to that state specifically, but the guy that you're, slandering or whatever, he lives in that state and they live in that state and that, word's going to get back there and it's going to ruin so-and-so's reputation, then yeah, you availed yourself to that.
What I thought was weird in that case was that they said that the harm to the reputation happened in California. So it was like a focus, it was like a targeted attack at California. But then something else happens, like, when there's an accident in New Jersey, it's like, even though the harm occurred in New Jersey, it doesn't matter. But
I mean, it was.
There's no targeting.
Yeah, they didn't try to do that.
It'd be like if they followed him to New Jersey and then it was a hit and run or something like that.
Or if they followed him from Delaware to New Jersey to try to run him off the road or something.
But then you get into a whole, like, then that could become a federal issue, right? So now you started a crime. Anytime you start a crime in one state and you end it in another state, now you're in like federal jurisdiction, like kidnapping and stuff like that, as soon as you cross state lines.
And then you open yourself up to the death penalty, even in states that have it.
Right. Cool. You guys got anything else?
I just want to ask everybody, am I the only one looking at the syllabus for con law for Graber? Because the book is, well, I could be mistaken, but I think the book is not out yet. But he says
It's not coming
still
in
not.
until
So he says all
October.
GGW materials for this week will be posted on Blackboard, but the only thing on there is the Pennsylvania Constitution. So I printed that out.
Yeah, there's a PDF that is like page like 49 through like 92. I think it's like right above that one, and it should have everything for the GGW.
Okay.
Yeah, because I'm looking for the Articles of Confederation, Brutus, Federalist, the Virginia Plan. I can't find, but those
It's
are
all
on
in the
there.
book. It's in that
Yeah.
PDF.
49 through
It's like
42.
chapter 3, it says, and then all of that is within that.
Oh, okay, thanks. I'm behind. Thanks.
No, you're fine. It's a second link on the top of the page.
Bowie says hi to everybody.
Chapter
Thank you, guys.
Thanks, Paul.
Hey,
Thanks,
yeah.
Paul.
If you guys run into anything else, like as a class, you're like, we are lost with this specific issue or something like that, just hit me up and like, I'm all about like helping out, whatever.
We appreciate
Thanks.
you.
And then I'll
Thanks so much,
post
Paul.
So,
I'll post this link so you guys can come back and look at my cat's butt again.
Can I ask everyone just a quick general question?
Sure.
For like time management reasons, how much time would you say you spent reading all of the different cases for Civ Pro? Like, I'm trying to figure out if I'm spending too much time trying to interpret these cases, because I feel like I spent like an entire day going through everything.
Less than last week, because I focused on
Yeah,
more important stuff.
I think
To be
about 30
honest.
minutes a case for me. That includes putting it into my spreadsheet.
Yeah, several hours.
And when you guys are doing the case briefs, do you read through the whole thing and then go and case brief, or do you do it as you go?
I do it as I go.
Yeah, I've kind of done it as I go too.
Okay, because I've been trying to do that, but then I feel like I kind of like, I get lost a little bit, like I lose the main point because I'm like reading a little bit and then going and filling out notes and then going back. And so I start to
You
confuse
could
myself.
do it in your book, but I don't know if you want to like highlight that much, but that's what I do is I like book brief. So I highlight everything and then once I'm done, then I go back in and type it into the spreadsheet.
Okay.
That's where
I like
color coding highlighters is like a lifesaver. I have like 6 different colors of highlighter in my hand as I'm reading, and I'm like, oh, there's the issue, green.
Yeah.
I guess I'm just worried how
Actually,
expensive that Pro book is on the resale value if I highlight in it.
Well, you can, so you could upsell and say, hey, put at the beginning, like in the like a lot of people
Annotated.
put, like on the thing, yeah, like green means issue, pink means holding, yellow means this, and then you sell it as like. But then people have to trust you. You might have to admit you got a C- in that class, and then it's worthless.
It's all about marketing, my friends.
Yeah, are you liable for the wrong highlighter color in the wrong location?
In a different state.
Jesus.
And
Paul,
I think it's
actually,
at that
do you
moment
mind
when I know
running-
it's time to sign.
Paul, do
All
you
right.
mind running through how you use your highlighters? Not to like, I know everyone has their own style and it's kind of, but I'm just kind of figuring out how to go about it. And I don't know, I think it'd just be insightful that someone who's been doing this for a couple of years already, like how do you assign the colors for what?
I mean, so the colors don't matter, but what you should
Yeah.
do is issue, rule, holding,
Okay.
and then I have a color for procedural history. Like, so if it says like the lower court did this, I'll have a color for that. And then I have one that's just for like facts. So like 5 colors is what I have. So I
Okay, that's helpful because I've been highlighting
facts.
the whole case just in one color. So I understand it kind of then goes with the chart. You're breaking it up that way.
But that helps. I think it was like, so like for what Max was saying, like if you just read, like try not to get bogged down in like stopping and doing your case brief as you're reading and going back and forth. And because then, yeah, you might just get bogged down in like the details of specific things and then you miss the whole point of the case. But instead it's like, as you're reading, you'd be like, oh, like, hey, there's the issue that they're going. And then you just real quick highlight that and then keep reading. And then once you've done all that, you can go back and like, make sure you hit all the points and you highlight everything correctly. But yeah, those
Thank you. That's helpful.
Question on note taking for con law. I guess when we're reading stuff like Brutus and like the Federalist Papers and the Pennsylvania Constitution and stuff, what should we be getting out of those things? What should we be?
Con law is the hardest one. Like, it is hard because those things are like just all over the place. It depends on what it is, and some like for note taking, it's just like thinking about like how it's like, so for you guys, you're starting on the institutions, right? So you're starting on like the development of the structure of the government. And so when you're reading those things, it's really about like figuring out like, how does this relate to, what does it evolve into? Does this evolve into something that like I need to know as far as like the basis of, oh, that's why the the taxing stays with Congress versus the president, something like that. Like it's tough sometimes. Sometimes like I know like for that class specifically, like the individual rights class, which will be con law 2, where you start to get into the actual Bill of Rights and the amendments, is a little bit easier because it's obvious. But for this one, like honestly, I was just taking notes as I was reading and highlighting things. I didn't really have a good color coding system for that. I just saw things that I thought was like, well, that seems like it. And then I did it the majority of my note taking while Graver was talking. That's when he gives you all the, like, this is what you should be getting out of it. I don't know how he's been doing it with you guys, but I know for us, it was, he'd like talk about it. And then if you were on call, he'd ask you like, basically what's your opinion about like what he just said. So it's easier that way, but it's hard to figure out sometimes what is the point of this thing that I'm reading? Because it's not as easy as like worldwide Volkswagen. It's like, there's the issue, here's the rule.
Right.
With things like reading the Federalist Papers, it's like, shit, I don't know.
I hear that.
Well, we didn't burn those 200 years ago, 300 years ago, or
now we just write musicals about the guys that wrote them.
that paint them in an unrealistically positive light. Anyway, okay.
Thanks, Paul.
Thanks, Paul.
Thank you.
All right, guys. Good luck.
Thank you all.
Thank you.